Hi there, I'm James Dappertune, and this is Coffee and a Case Note. Today, team, we are talking about a big decision. It's an application pursuant to Section 411 of the Corporations Act for approval of a scheme, of an arrangement in relation to a company. Now, there's lots of arguments about this, including the headcount test and whether the court ought to approve this scheme that's essentially pressed by a majority shareholding, but they didn't get the headcount they wanted in relation to the proposed scheme. We're not going to dive too deeply into that. Today, like many days, we're going to take an oppression angle. So we're going to extract the oppression point and have a chat about it. Now, what is this scheme? The scheme is that a group that we might loosely call the majority want to go through with a re-domiciliation scheme. They want to move the domicile. They want the company to be no longer based in Australia. What they're proposing is let's move it to Canada. Now, there are all sorts of reasons proffered for moving the scheme, moving the company from being domiciled in Australia to being domiciled in Canada. Tax and proximity to the market, the chief customers and efficiencies and these sorts of things. But that re-domiciliation is opposed by a majority. Now, I withdraw that. It's opposed by a minority. And one of the reasons for the minority's opposition is that the re-domiciliation, the moving of the company from Australia over to Canada, would cause the shareholders to become security holders. So in Australian law, they're shareholders. In Canadian law, they hold security. So let me get that shareholder, security holder distinction in your head. Now, the reason it matters to the minority, one of the reasons it matters to the minority, is that they have Section 232 oppression proceedings on foot, a separate piece of litigation. And pursuant to Section 234, oppression proceedings can only be conducted by a member of a company. Now, what the minority say is a member is a shareholder. We've got our oppression proceedings on foot because we're members, which are shareholders in Australia. If you re-domicile us to Canada and we become security holders, then kaboom, poof. Pursuant to Section 234, our oppression suit just disappears into nothing because we're no longer members, we're no longer shareholders. And so what the minority say is, due to the fact that our oppression suit would disappear into thin air, that is one of the reasons to oppose approval of this scheme pursuant to Section 411. So the court has to consider this. And what the court finds is, in short, that Section 234 of the Corporations Act requires you to be a member to start an oppression suit, right, to commence Section 232 oppression proceedings. But you don't need to be a member to continue the proceedings. So the court says, don't worry, you were members, you were shareholders at the start of the oppression proceedings, and you're now going to become security holders if the re-domiciliation goes ahead. That's another issue. But that shift from shareholder to non-shareholder does not of itself remove standing. You can still progress with the oppression suit. But if you start an oppression suit when you're a shareholder, the court makes this comment, and then you stop being a shareholder at some stage, that might affect the court's view on granting oppression relief. Okay? So in order to kick it off, you've got to be a shareholder, but to continue it, you don't necessarily have to be a shareholder. And remembering that in an oppression suit, to get Section 233 relief, the whole point of that relief is to cure the oppression. So it might make it a bit difficult for you to argue that you're being oppressed if you're not a shareholder. So I hope the rule of you've got to be a shareholder to kick it off, but don't need to be one to continue it, that was highlighted in this decision, assists you when you're reflecting on the law of oppression and all these sorts of interesting things. And I'm really going to look forward to joining you for another coffee and another case note soon. Cheers.